you for tuning in to our annual video series from the International Symposium on Human Identification. Today we are very honored to be speaking with Mike Ware. Mike, why don't you tell us a little bit about yourself before we get started?
Well, thank you for having me. So I'm a lawyer. Let's get that out of the way. I graduated from law school from the University of Houston in 1983. My wife and I and our then two kids, we now have three, moved to Fort Worth, which is where I was raised. And I clerked for a federal district judge for a year. And then I opened up my own law practice in 1984 and doing mostly criminal defense, but not exclusively. And then in jumping forward in 2006, a law school buddy of mine and I co-founded the Innocence Project of Texas as a 501c3 nonprofit.
Let's talk about that. Why did you co-found it and what's its mission?
Well, I became really interested in innocence work. When I first started practicing, nobody was innocent. I mean, in the general perception, and if you had a client who you believed was innocent, you didn't try to pitch it that way with the DA's office if you were trying to work something out, because they immediately, thought you were either naive or a bullshitter, because nobody's innocent. And then Barry Scheck and the National Innocence Project started their DNA post-conviction work, and these sort of astounding exonerations with incredible stories started coming out, and I kind of got really interested in that. So anyway, we had some meetings with the National Innocence Project, and we ended up starting our own in Texas.
Very interesting. How does this relate? I believe when you were in Dallas County, you were working on some conviction integrity. Did that lead
Right.
to this, or did that?
No, it all sort of happened simultaneously. In the fall of 2006, Craig Watkins got elected as the DA in Dallas County. And Dallas County is just to the east of Tarrant County, which is where I primarily was practicing at the time. But I'd had cases all over the state, including Dallas County. And at that time, Dallas County, at least among defense lawyers in Tarrant County and other places, really had a bad reputation in our mind, in that we were treated much more poorly over there than we were in Tarrant County. We were told, Tarrant County had always had an open file policy. It wasn't completely open, but at least they called it an open file policy for discovery. Dallas County didn't. If you asked for a discovery in Dallas County so you could get ready for trial or get ready how to advise your client, that they might tell you, well, go talk to your client. He or she was there. They know what happened. That's your discovery, And so when Craig got elected, the first African American ever to be elected DA in Dallas County, or anywhere in Texas for that matter, and as an outsider, he was not someone who had ever actually been a prosecutor in the Dallas County DA's office. He ran against the de facto incumbent who had been the previous DA's first assistant, and won. And so first off, in Tarrant County, we were kind of bemused by it, because there was this perceived panic in the DA's office. Someone from the outside was coming in and was going to expose all the wrongs that had been committed over the last 40 years there, and or something along those lines. But then he asked a real good friend of mine, Terry Moore, to be his first assistant. And she was a defense attorney at the time. She had been a top felony prosecutor in the Tarrant County DA's office. She had run for DA in Tarrant County and had lost to the incumbent twice. And she'd been a federal prosecutor. So she was a really good, wise choice on his part to pick as his first assistant, because she knew the politics, she knew how to try a case, she knew how to run HR, and generally, particularly in the larger urban areas, the elected DA is the politician. he gives speeches to the Rotary. He or she gives speeches to the Rotary Club, to the Chamber of Commerce, whatever, and campaigns for reelection. And they call them different in different offices. First assistant, whatever, is the one that actually runs the office. And so that was Terry's position in his office. So her idea, and she started in 2007. Actually, she and I tried a case together in 2007, and she went over there right after we had tried that case, finished trying that case. And she had the idea of starting what she called a conviction integrity unit. I'd never heard that term before. I don't think it had ever been used before, but there had never been one before. And her idea was to look at questionable convictions and do it, from within the office, which is a much more effective way to identify and ferret out wrongful convictions, innocent people who have been wrongfully convicted. And see, up to that point, well, in 2001, Texas passed one of the first, maybe the first, post-conviction DNA testing statute, which allowed inmates, if they could meet the criteria as set out in the statute, to access to biological evidence, to DNA test, to prove their innocence, which until that point, they had no right to do that. And of course, the prosecutors had the right to contest it. And many times prosecutors did because they didn't want them to test it, because if they can prevent them from testing it, they can, stop short a potentially embarrassing exoneration. That's my take on why they would fight testing. Otherwise, why not let them test? It's either going to confirm their guilt or prove their innocence. Doesn't everybody want to know? And so, anyway, Dallas County had started having a string of DNA exonerations leading up to Craig's election. And understand, these were inmates who applied to have post-conviction DNA testing. The DA's office had fought them having testing successfully in a lot of cases. So we may never know, or at least at that point we thought we would never know. But these were the ones that had somehow won. Sometimes they had to go all the way up to the Court of Criminal Appeals to win, and then had come back and been exonerated. And so her thinking, and it made sense, was that if these guys, and every one of them was just sort of a tremendous story. It's a tragic but spectacular at the same time, And her thinking, and like I said, it made sense, was that if there's this many exonerees, with the Dallas DA's office fully resisting, most of the time successfully, to them even getting a test, just think how many more there must be out there who never even got a shot at it. Or maybe think of all the cases where there isn't any DNA, So when she offered me the position, wanted me to come start the conviction integrity unit. It had to go through the county commissioners. There was a lot of drama there. It was a 3-2 vote. 2 of the commissioners were adamantly against it. It was like, this is not your job. DA's office is to lock everybody up or put them on death row. Your job is not to exonerate innocent people. And so there was, that discussion. Nobody's ever done this before. What are y'all doing? This is crazy. Y'all don't know what you're doing. You're gonna mess up terribly, or worse. And but it got through on a sort of a 1-year make good, and they allotted the money for it. It was me and another attorney working under me, and then a full-time investigator who was a law enforcement officer, and then a paralegal. And so our first task was to go back and look at we had a database, requests for DNA testing, and to see who had asked for testing but who had been denied testing because the office was opposing it, and the judges almost always go along with what the DAs want. And see if any of those guys, or women, whichever the case may be, I think it was almost always guys, which one of them really should have gotten testing, in that, there's DNA to test, and it will either prove they're innocent or prove they're guilty. So what's the worst that can happen? You know? And so we started doing that, and we started, doing, contacting their attorneys, doing tests by agreement, and started getting exonerations that way. People who had been denied a test, we gave them tests, and it proved their innocence. In some of those cases, I'm thinking of the Patrick Waller case in particular. Patrick Waller was the very first inmate to apply for DNA testing under the new 2001 statute, and it had been denied. He was denied because this was the argument. The crime involved a sexual assault of a woman, but the perpetrator had stolen her car also. And so there was DNA to test, and it was tested under a much more primitive way. And supposedly it identified him as part of the 13% of the African American male population that had this particular blood type. But he was tried for robbery, not sexual assault. So they said, so it doesn't matter whether he sexually assaulted her or not. Well, that's crazy. But the judge bought it, and it was upheld on appeal. And so we said, let's go ahead and test this. I mean, that's like saying, well, fingerprints don't matter because they weren't convicted of, having fingerprints. And so it wasn't him. We had the Texas Department of Public Safety, law enforcement lab test it. They got a clear male profile through, DNA testing. It was not him. They put it into the national database. They identified the actual perpetrator who was in the national database and who had just paroled out on another violent offense. So we were able to go interview him at his parole officer's office. We caught him when he was reporting to his parole. And on audio tape, he eventually confessed to it. And there was actually a second actor in this, and let us know or told us who his co-defendant was, who we found subpoenaed to the grand jury. And he admitted to everything in front of the grand jury. We had to give him immunity, which really didn't matter because the statute of limitations had run on both of them by that time because the earlier administration had not pursued it. They didn't really care who did it. They had a conviction. That's all they wanted. And had they pursued it when Patrick first asked for a DNA test, they could have identified these guys in time to prosecute them under without running afoul of the statute of limitations.
That's an excellent example of how this works. Looking from the outside, it seems logical, although difficult, to have a convictions integrity unit inside as well as people from outside who are looking at it. It just makes sense to expose the most cases, but I can see how you would get quite a bit of pushback from people within the office. Are there other units like that now that you've begun this in Texas?
Oh, yes, there are. By the way, just as a footnote to the Patrick Waller story, when we identified these two guys, some of the original police investigators started spreading the rumor, well, actually, maybe there were 3 people involved. And which, anyway, that aside, that's the kind of pushback we're getting, in the 4 years I was there, I think we exonerated 25 men. They were all men. And, and there were some that we started and they actually, was finished. It can be a lengthy process, finished up after we left and such. But it got enough, publicity, really internationally. I remember there was a write-up about what we were doing in a Russian newspaper. But all over it, because it was such, whoever thought of this, just such, mostly DAs run on pounding their chest and talking about how tough they are on crime. And of course, we like to think, well, we're just as tough on crime. We just want to get the right guys, locking up the wrong guys is not being tough on crime. And but anyway, district attorneys all over the country in Texas were sort of taking heed. I think they were very honestly sort of envious of all the political favor this was generating on Craig's part, and who knew, because everybody was predicting dire things. This is going to be the worst thing you ever did. He'll never get reelected, and it turned out just the opposite. And so Craig kind of became a rock star.
I can see how it was a big risk, but in any other industry, you usually do have some form of internal, accountability, audit, something. Right. So it really seems to make sense.
Sure. Yeah. And so there were DAs all over the country that wanted to be rock stars too, or have a part of this. And they all had, I think, different ideas on how this should work. But to answer your question, yes, they're all over the country now and all over the state, and they all, operate differently, depending on, who's in charge and what the culture of the office is.
Having gone through this, do you have any words of advice for those who want to re-examine cases, want to put in a unit like this?
Well, sure. I mean, I guess, number one, the unit and whoever's head of the unit shouldn't have to be answerable to anybody except the DA or maybe the first assistant. They shouldn't have to answer to head of appellate. They shouldn't have to answer to, whatever. They should be able to operate freely. Preferably, it should be somebody from outside the office and not a career prosecutor. And look at all cases. Don't exclude. I know there's some offices say, well, we don't review pleas. If they pled guilty, a card laid's a card played. We're done with it. So we're not going to review one. Well, if you look at the National Registry of Exonerations, an astounding percentage of those exonerees pled guilty. And anybody who does this work knows that innocent defendants plead guilty. I wouldn't say all the time, but it's not unusual.
I would imagine, to receive a lighter sentence if they feel there's no way they're going to get justice.
Well, sure. They feel like they don't have any confidence in their attorney, either because, they're court appointed and they didn't choose the attorney. Or they just, they've just seen too many people sentenced, who they've been locked up with go down and get sentenced to life after trial or whatever. And it's if they are offered a lesser sentence or a lesser charge or something, then it's not unusual for their own attorney to pressure them into taking it, even if they insist on their innocence.
So let's talk more about what you're doing now. Like how does the Project of Texas decide what cases to re-examine? Where are you in the process?
Well, we receive, I usually say 100 letters a month, but maybe it's not quite that many. Maybe some months it's more. But we receive a lot of letters from inmates, from families of inmates, from friends of inmates, from somebody who knows somebody who knows somebody. And so we have a process by which, we document all that. And we have somebody who looks at them initially and decides whether or not this is someone who's really asking for assistance that we provide. Because sometimes they're not. Sometimes they're complaining about, what unit they're in. They want to be moved. Sometimes they, want help with their divorce. Sometimes there are other legal problems that we don't handle. We're not an all-purpose legal services agency. And we try to steer them in the right direction. But someone makes an initial determination whether this is even the sort of thing we deal with. And then it goes through some vetting steps, but typically it will then go to a group of students. We run we have the Innocence Clinic at University or the Texas A&M School of Law, and which is there in Fort Worth, and then at Texas Tech Law School. So our deputy director, Allison Clayton, runs the clinic at the Texas Tech Law School. And so we have students, well, prior to that, we have someone who gathers all the relevant documents so that somebody can look at it and make some kind of judgment. That's a very time-consuming process and can be very costly. We've got to get the entire trial transcript, for example, hunt that down. I mean, maybe the trial was in 1992, so we got to hunt that down and pay for it, et cetera, before we can, make it an informed determination as to whether it goes to the next step. Get all the investigative reports, get everything we can, and then we assign them to students, and we discuss them in class. The students review that, and from there we start weeding out what cases we need to close for whatever reason, what cases should go on to the next step, which cases should be assigned to an attorney, and where to go from there.
How long does this process take from start to finish, typically?
Let me use two cases that come to mind. The San Antonio 4 case, I picked up right after I left the DA's office in 2011, and they were finally exonerated in 2016. That's considered fairly quickly. Lydell Grant, that I'm going to talk about some tomorrow, I guess we picked that up in about 2018, and he was finally exonerated in 2021. So that was fairly quickly. And I think if you talk to people like that have done this a long time, they'll tell you it's not unusual to take 10 years or more.
That's an enormous amount of time. I'm not sure even the general public realizes, what goes into this.
Right. Well, I mean, there's so much resistance to it, though. Once someone is convicted, all the procedures, all the laws, everything are stacked against you. In Texas, what you have to do is we have to prove by clear and convincing evidence, with new evidence. It can't be evidence that was known at the time of trial or could have been known at the time of trial. Even if they didn't know about it, well, if you'd been diligent, you'd have found out about this. And so it proves that you're innocent, but too bad. You could have proved you're innocent at trial. It's too late now. So that's a pretty heavy burden, and there's a lot of procedural hurdles because, for example, often what happens that we run into, and it's very frustrating, although I understand why it happens, is, an innocent person, goes in, they've lost at trial. And sometimes it's a shock because they believed in the system. And how could I lose? How could they present so much evidence to convict me when I didn't do it? How could there even be evidence that I did it if I didn't do it? So then they get, a direct appeal, and they lose that. And then, they're no longer entitled to a lawyer. And so they file their own pro se writ, explaining their arguments or whatever as best they can. And the Court of Criminal Appeals will look at it and say, I'm not reading this, denied. Now they've had their one bite at the apple. And generally you're only allowed one writ. So if after that they come to us and say, look, here's what I've got, and go, this is a great case. This person's innocent, we can prove it, but they've already filed a writ. So we're barred. We can't file another one unless we meet some very difficult or are able to overcome some very difficult procedural hurdles, and it's infuriating, but that's what the law is.
How often does that happen when they've already filed a writ and you have to meet that? And how often do you get lucky and that hasn't happened, but it is a good case for you to take?
Most of the cases we get, they've already tried to file their own writ. And so there are exceptions that it's just an extra hurdle. And they're not easy to meet. And it's an extra hurdle that we have to overcome just to have the merits of the case heard. And that happens with some frequency.
So I think sometimes the perception of the public, because of the TV shows that are out there, the series everyone watches, they think, oh, someone says I'm not innocent, someone comes to help them, there's a DNA test, and boom, they're exonerated. Let's talk about the technologies and how the changing technology has assisted in the work that you do.
Well, one thing, what time has done is expose all the BS pseudoscience that a lot of people got convicted on, and a lot of the mistaken testimony, in some cases out and out false testimony that went into getting people convicted by so-called experts. And so we were able to get in 2013. I said we do some policy work. We were able to get a statute passed that was called the junk science statute, and basically, and it was amended in 2015 to fix some holes in it that the courts were able to find in order to pour our clients out on technicalities. So we had to amend it 2015 to shore those up, and what it says, if someone was, in a nutshell, if someone was convicted based on what we now know is bad science, it's a little bit more particular than that, but that's basically what it says. And but for that testimony by this so-called expert, they would not have been convicted. If there's some reasonable likelihood they would not have been convicted, then they're entitled to a new trial.
Okay.
Or if there's an advance in science that can be applied to their case that was not applied back then. So either bad science at their case that can now be disproved, or new science that could be applied to get them a new trial.
Are there patterns that you've seen in all of the cases that you've been working?
Yes, and of course there's this what's called the National Registry of Exonerations. That's full of information that has been, collected, categorized, etc. That talks about that. It's run by academics and others who are experienced in the field, and you can find out, what the answer is based on the thousands of exonerations that they've been able to document and collect data on. But my own personal experience, the first thing that comes to mind is mistaken eyewitness identification, and which is in many cases, unfortunately, the product of police misconduct. A lot of police misconduct is disguised as mistaken eyewitness identification, and what happens is, there's eyewitnesses, they can't describe the person, and so the police find a suspect, and maybe it's the person who did it, maybe it's not. We found plenty of cases where it was not. Put them in a photo spread, and then basically tell the witness who to pick. And that can be very overt, or it can be very subtle. But it's the problem is the detective who knows who the suspect is administering the photo spread, and so and then they can even, if they pick the right person, they can even congratulate them and reinforce that they picked the right person. And so what we did, once again, is we went to the legislature and made our case, and got a law passed that the police are supposed to administer photo spreads in a double-blind manner, so that the person administering the photo spread does not know who the suspect is, and it's made a big difference, so we saw so many cases where in Dallas and otherwise where, we're like, well, how did this guy even become a defendant? I mean, how did he become a suspect? I mean, I understand he got put in a photo spread and picked out, but how did he get put in the photo spread? And I understand once he's picked out, he's going to be convicted no matter what, because, that person is now going to come to court and is going to say, that's the man who robbed me or sexually assaulted me or whatever. And the jury's going to believe it. And that person is not going to walk out of the courtroom. And of course, DNA tests started exposing all that, and a lot of times when we identify the actual perpetrator, they didn't look anything like the person who was mistakenly identified. And so you go, well, how does that happen? And we interviewed enough witnesses to know that with some frequency, they were told who to pick.
So it's really remarkable that DNA has allowed you not only to exonerate these people, but to identify procedural errors that can then hopefully be corrected
True.
And change the process.
True.
Yeah, that's amazing. Now, you mentioned a case earlier. Is there one particular case that really stands out that's, I'm sure a lot of cases stick with you, but is there one in particular that you just can't forget?
Oh, whatever the last case exoneration was. Kind of like my favorite movie, whatever the last movie I saw was.
Yeah.
I mean, I hate to be,
sense.
I'm not trying to be flippant about that.
Oh, and I don't think so. I mean, that makes sense because they all matter that much is
Yeah.
what you're saying, basically. Yeah.
But yeah, I mean, I could go down the line, because every one of them truly is an amazing story. And what it causes one to realize is that for this person to get exonerated, this had to happen, this had to happen, this had to happen, this had to happen. What are the chances of any of those things happening, much less all of them happening in the same case? The logical inference from that is there's a whole lot of people in prison innocent people who've never been identified, or if identified, have never been able to successfully be exonerated. So for everybody who's exonerated, I would say there's conservatively 10 or 15 who've never been identified or exonerated.
Wow, that's a remarkable number. I mean, it's shocking. There's a lot of work to do and takes a lot of time. Let's talk about the students just a little bit to circle back. It's really interesting and wonderful that you're working with students. What's that like?
Well, I really enjoy it. They're very smart. They're some of them think they're cynical, but they're not cynical yet. When what's interesting is when I present them with the way things work, they're like, "What? The United States Supreme Court does not recognize actual innocence as a grounds for relief, which is true. How can that be? What? Here's the case where they proved this, this, and this, and the prosecutor still wouldn't agree that they were innocent and made up these alternative theories. I mean, what's wrong with these people?" And there's a law professor and author, Laura Bazelon, who's written on the subject, I think a book, law review article on innocence deniers, where she catalogs just some for instances around the country where someone is proven they're innocent beyond all doubt, and yet the prosecutors would come up with some cockamamie theory of how they could still be guilty. Kind of like I referenced a while ago in the Patrick Waller case. Well, maybe there were 3 people and not just 2. I mean, that kind of thing. Some of them are much more far-flung than that. And I'm still trying to come up with an answer for them, with how can they do that? How can they say that? And the only one I've been able to come up with, that's the most honest answer I can come up with, is they're just assholes. These judges, these prosecutors that won't give relief where it's so obviously, should be given, or whether, or who, you know, come up with these cockamamie theories by which, even though this, and this, then they're still guilty because of this completely new theory. They're just assholes. I mean, I wish I could come up with a more academic answer than that.
I mean, I don't know. Sometimes I think we see it again and again in different places, that confirmation bias. Once you've said something, nobody wants to change their mind.
Oh,
and
yeah.
it's difficult to overcome.
They cannot hold two different ideas in their head at one time. That cognitive dissonance is just too much for them.
What made it so important for you to bring this to ISHI and present for us this year?
Well, I didn't even know. I'm so glad to know that ISHI exists, and this conference has been great. I didn't even know it existed, but I guess a DNA expert that we use as a consultant and as an expert, and has helped me out on so many cases, including the one I'm going to talk about tomorrow, Angie Ambers, connected us, and I guess she thought that maybe I would enjoy doing this, and that, you know, maybe it would be a good fit. And so I said, sure, I'll do it. And so here I am.
We are so glad to have you here. We really appreciate it. And the experience has been good for you so far?
Yeah, it's been great. I want to send somebody from our organization, our nonprofit, here every year, I think. Now that I've seen what goes on here. I mean, there's so much that I've sat and listened to. I go, this is fascinating. I don't understand it, but it's fascinating, you know, and I need to know it, you know, because my work involves so much of it, you know.
And I think that's what we see a lot of, you know, we see, you know, where academia meets law enforcement, meets forensic DNA, scientists, all of the technical specialists.
Right.
Yeah. Well, we really appreciate you being here, Mike. Thank you so much. This was
thank you.
wonderful. Yeah.
Thank you.
Thank you.